Derek was still at the hospital when the adjuster called. Her voice was calm. It was professional. She explained the comparative negligence law in personal injury cases. If a jury finds you partially at fault, she said, you may not be able to recover anything. The other driver had run the red light, but Derek had been going 8 miles above the speed limit. That made him partially at fault, according to the adjuster. Partly at fault, she made clear, put him dangerously close to the line. Derek thanked her and walked away from a real claim. Derek was not primarily at fault. She needed him to believe he was. You see, Texas goes by the 51% rule when it comes to comparative negligence. If you are 50% or less at fault, you can recover for the percentage of damages that you were not at fault for. Comparative negligence is one of the most misunderstood pieces of Texas law in the claims process. Adjusters may use this early on to shut down cases before they ever get started. The most important thing to know is that being partly at fault and being completely at fault are two entirely different things. And there are specific moves adjusters may make, starting with that very first phone call, to push your fault percentage up as high as possible in your own eyes so that you will devalue your own case. But we're going to walk through what this rule actually says, how fault percentages get determined, and what the first call with the adjuster is really doing to your case. What the 51% rule actually says. Texas operates under what is called modified comparative fault. The formal legal name for this is proportionate responsibility. What that means in plain terms is if your share of fault for the accident is 50% or less, you can still recover damages from the other responsible parties. Your total recovery gets reduced by your percentage of fault, but you don't lose everything. Now here's how the math works. Let's say your damages total $100,000 and a jury finds that you were 20% at fault. You walk away with $80,000. 30% at fault, you get $70,000. 50% at fault, you recover half. And if that number reaches 51%, you get nothing. The bar completely drops once you've crossed that threshold. That 1 point shift from 50 to 51 is the cliff edge in the Texas personal injury case. Everything an insurance company does in the early stages of your claim is built around that number. They're not trying to figure out what's fair. They're trying to get your number to that line, or at least convince you it's already there. Here's the thing. Most people do not know about how fault percentages actually get set. The adjuster does not have the legal authority to determine your fault percentage. That's not their call to make. You see, if your case goes to trial, it's a jury that assigns the fault percentages. They hear testimony, they review evidence, they consider expert analysis, including accident reconstruction, and then they deliberate on all the facts. Then they assign percentages to each party involved, and those percentages total 100% across all responsible parties. No claims department, no adjuster, no insurance company makes that determination. A jury does. But adjusters don't wait for juries. From the moment you file the claim, they are building their internal fault picture. They're making their arguments, and they use everything you give them to do them. The recorded statement they take is not documentation. It is positioning. They call you early, sometimes while they're still managing your injuries, because that's when you are most likely to say something inconsistent or volunteer details that might raise your fault number. Every account of the accident you give before you have legal representation, that gets filtered to one question. Does this move your fault needle percentage up or down? Your social media may get reviewed. Any gap between what you said in week 1 and what you said later is going to get noted. Adjusters are not neutral fact finders. They work for the insurance company. And the 51% bar is the most efficient path they have to a $0 outcome on your claim. Let me walk you through 3 situations that I see come up pretty regularly. These are composites based on types of cases I have handled. First, you're rear-ended while driving over the speed limit. You were going 10 miles an hour, the driver strikes you from behind. The adjuster hears that and immediately builds an argument that your speed contributed to the severity of the impact, or placed you at the exact point of the road at the exact moment. Here's how Texas actually looks at that in a rear-end collision. The following driver generally carries the primary fault. The fact that you were speeding does not automatically make you equally responsible or more responsible for getting hit from behind. But the adjuster will frame it that way until somebody with legal standing pushes back. The framing is the first move. T-boned after going through a yellow light. The other driver says it was already red when you entered the intersection. You say it was yellow. No cameras at the light. Now fault is genuinely disputed, and without strong physical evidence or independent witnesses, that dispute can result in a range of directions. What matters most is what was documented at the scene immediately after the crash, whether anyone else observed the signal, and whether you gave recorded statements before you understood how those statements would shape the fault analysis. Rear-ending someone who stops suddenly. This one is harder because following drivers typically carry some level of fault in rear-end situations. As we said before, they're often mainly at fault. But if the driver ahead had non-functioning brake lights, if they cut across multiple lanes and stopped abruptly without warning, if a chain reaction from another vehicle forced the stop, those facts shift the analysis. The fault picture is different. The point is none of these situations are as settled as the adjuster's first call can make them seem. The actual facts, examined carefully, often tell a more complicated story. Here's what I've seen happen when people accept that first framing without pushing back. I've had clients come to me after they've already walked away from their claims, not after a court ruled against them, not after a jury came back with a bad result, but they walked away because an adjuster told them, "You're partly at fault." The client just assumed, well, okay, that's the end of it. They felt embarrassed. They thought if they contributed to the accident at all, they didn't deserve anything. But that's not how the law works. Those are the cases that stick with me, because when we look at the underlying facts, in several of those situations, the fault split would have likely landed well under 50% on the client. Real injuries, real medical bills, real months of lost work, and they left it on the table because they accepted an early opinion from somebody whose entirely financial interest was getting them to walk away from their claim. Here's what you need to understand. The adjuster's fault estimate in week 1 is not a legal determination. It's a negotiating position. The actual determination, if your case ever reaches that point, belongs to a jury with evidence from both sides. The 51% bar is established under Texas law, but the number assigned to you under that rule is not the adjuster's call to make. It's a question that deserves real legal analysis before you accept any answer. If you were partially at fault in that accident, that doesn't close your case. It means there's a question worth asking, with someone in your corner to help you answer it honestly. This is why I made a full video, which you can find on the YouTube channel, about what not to say to an insurance adjuster. Every word you give to them is basically a data point that they can use to push your fault percentage up. Watch that video next. And if an adjuster's already told you that you were partially at fault, remember, that's what they gave you as an opinion with a financial interest behind it, not the final word. My name is Paul Cannon. I'm board-certified personal injury trial lawyer in Texas. I'm the managing partner of Simmons and Fletcher in Houston. Before you walk away from a claim, it's worth having a lawyer look honestly at where your fault percentage lies. Has an adjuster ever told you that an accident was partially your fault? Did you know about the 51% rule before today? Tell me about that in the comments.